Welcome everyone to Unit 7 on third-party intervention. This is Dr. Moore. The term third party refers to a person or persons who become involved in a conflict to help the disputing parties resolve it. The following true story shows the need for third parties. An Israeli settler in the West Bank began pointing his gun at a crowd of unarmed Palestinians harvesting olives. Attempts at reaching a compromise between the two had not lessened the danger. All of a sudden, an elderly Israeli stepped in front of the settler's gun. According to a peace activist, every time the settler pointed his gun at someone, this 70-year-old man would block it, the barrel pointed at his chest. This act of courage emboldened the Palestinian villagers who sat down in the olive grove as an act of civil disobedience as Israeli soldiers began to arrive. Other activists from the United States, Israel, and Palestine, all members of the International Solidarity Movement, negotiated with the Israeli military over the Palestinians' right to harvest. Having prepared themselves with knowledge of Israeli military codes, the activists successfully convinced the soldiers to escort the armed settler out of the olive grove. Of course, not all conflicts reach this level of intensity. Conflicts happen on a variety of levels and over a variety of topics. Sometimes the conflicts become too difficult to resolve on our own, so we turn to a third party to help. Many times, parties involved in a conflict seek help from a third party after falling into a destructive spiral. A competent third party can help resolve a conflict and improve the relationship. Now, we may ask them for help directly or indirectly, or a benevolent bystander like the 70-year-old man may step in. On a broader level, peacekeeping organizations may step in as well. Third-party intervention in human conflict has a long history. Commonly, negotiation is pursued when two parties have incompatible goals or values between them to reach a mutually acceptable agreement on these issues. Across societies and all levels of social interaction, there are third parties whom people can turn to when they find they are unable to manage their differences by themselves. Let's take a look at some of the advantages of skilled third-party intervention. A skilled third party is someone with training and someone who doesn't have a vested interest in the outcome, so they can be objective. The goal is to transform the elements of conflict so a settlement can be reached and the conflict can be put to rest. This transformation can take several forms. First, it can change the style of expression or alter the degree of interdependence between the parties so each side can see how they need each other to reach their goals. It may change perceptions or goals so they are not seen as incompatible. It may balance the power or modify actual or perceived scarcity of resources. Finally, it may adjust the actual or perceived interference by the opposing parties. To intervene or not to intervene, that is the question. In which of the above situations is third-party intervention appropriate? A. Members of two different fraternities are being destructive to one another's property. B. Two girls are fighting over a doll, and unexpectedly the doll is ripped in half. C. Co-workers say they're being paid drastically different salaries for the same job. Or D. A couple who disagrees over the custody of their child yet doesn't want a judge to have the final say. Interestingly, all of the above. All of these situations could benefit from third-party intervention. In each situation, the best intervention would take a different form. Adding third parties to the two-party negotiation process is helpful for many reasons. Negotiations are often tense and difficult and can lead to frustration and anger. Negotiation over critical issues may reach an impasse. And third-party intervention may be the only way to get negotiations back on track. Now, there are two types of third-party intervention, formal and informal. Informal help is provided by someone who is not trained in third-party intervention. Forms of informal help come from friends, coworkers, neighbors, and family. If you decide to intervene as a third party, you need to answer several questions. Are they really ready for a third party? And what evidence do you have that indicates readiness? How do you know that they want you to help? What skills prepare you to help them? Can you best help them by referring them to someone else? Are you biased, committed to one of the parties, or unable to help because of time, position, or other matters? Can you say no? If not, then you're probably too involved to be an effective helper. Remember, you have a choice. If you don't think you should get involved or are reluctant, you probably shouldn't try to help. Some cautions about formal intervention. Be certain the parties want help in managing their conflict. Did they both agree for you to help? Avoid becoming the enemy. Remember that you're entering a system, and if you become the enemy, you won't be helpful in getting them to work through their differences, as their focus will be on you. You must constantly remain aware of coalitions. Avoid siding with one or the other, as it creates a winner and a loser and upsets the balance of power. And once the work is completed, the third party exits from the system. Your goal is to improve their relationship so they can manage their own relations. Formal intervention methods differ in that they require specific training or education, and these methods differ according to the degree to which conflict parties determine the final outcome. They include coaching, mediation, counseling, arbitration, and adjudication. Another way to think of this is at the high end of the continuum, the parties decide. At the low end, an outsider decides. We'll take a look at each of these types of formal intervention in the next slides. At the high end of the formal intervention continuum is coaching. It's an option for those unwilling or unable to engage in mediation. It helps clients work toward handling conflict and can be mixed with other forms of help, such as preparing clients to enter mediation. It may be both short-term and long-term. However, it often addresses a specific situation. Conflict coaching helps one party understand and manage conflict, whereas a mediator works with both parties. A relational coaching model helps people deal with identity, power, and strong emotions in their disputes. And it teaches more productive responses. A coach looks for opportunities to transform conflicts. Like mediation, the process is voluntary. Coaching requires emotional intelligence, excellent listening skills, and an ability to reframe situations in order to allow resolution to occur. A coach helps the person explore what they would like to see happen, perhaps asking the question, "What does it look like for you?" People retain a conflict resolution coach to develop their conflict competence and make changes in their approach to conflict. Also, coaching helps prevent unnecessary escalations in conflict. The next mode of intervention is counseling. It goes deeper. It goes beyond communication patterns. Counseling involves resolving disputes by examining all the issues, be they relational and emotional, in addition to the topic issue. It may involve examining deeper issues such as low self-esteem, depression, substance use, anxiety disorders, or personality disorders. And counselors don't control conversations like a mediator or an arbitrator might. You should see a counselor if your feelings are so overwhelming that you can't be productive or cannot communicate effectively. If you feel isolated, or if you have very low power and need an advocate. Let's move on to mediation. A mediator has no power to make a decision or impose a solution. Instead, a mediator works with both parties and allows them to work through their problem together. A mediator listens, helps parties to negotiate, and is there for the agreement process. A mediator controls the conversation but does not control the final solution. The mediator intervenes to stop destructive moves by either party, such as name-calling and other disruptive comments. Shuttle diplomacy is common where the conflict is particularly intense. This is where the parties are separated and messages are shuttled back and forth by the mediator. This sometimes happens in divorce mediation. The mediator gives equal benefit to both parties, and the bottom line in mediation is the parties create their own settlements. Mediation certainly has advantages, mainly because the parties are actively involved in the negotiation. Mediation reduces the cost of protracted disputes. It's a lot cheaper than going to court. Mediation increases satisfaction with the outcomes of the dispute. Agreements are integrative and creative. Mediation enhances relationships among people and reduces the recurrence of conflict. And it's appropriate for many contexts, including marital disputes, workplace disputes, teacher-student disagreements, and even conflict among members of a homeowners association. As with any resolution process, there are limitations. First, not all parties can agree to work it out, and some people are not willing to work collaboratively with what they call their enemy. Perhaps they don't value the relationship enough to work toward a solution. And it's not appropriate for certain relationships. Parties have to be committed to working on the conflict. Or in cases of physical or emotional abuse, the victim may not be able to speak up for herself or himself. If physical abuse has been present in the relationship, it may be difficult to deal with the power imbalance. And finally, small disputes are not worth the effort. It may not be serious enough to work through this process together, and it could be better handled through small claims court, for example. As we continue to move along the intervention continuum, we get to arbitration and adjudication next. In these modes of intervention, the communication pattern is quite different, and an outsider decides what the solution will be. Now here, I've recreated the communication models from the text to point out the profound difference between mediation and the final two modes of intervention, arbitration and adjudication. On the left, you see the mediation model. And note how there is interactive communication between party A and party B facilitated by a mediator. Also, pay close note to the model on the right. There is no provision for communication between the two conflict parties anymore. It's gotten to the point where the two cannot discuss the conflict constructively anymore, and they rely on their representatives or lawyers to argue their cases. As you saw in the previous slide, arbitration and adjudication share an identical structure. In both arbitration and adjudication, a third party is empowered to decide the outcome of a conflict. Parties who cannot resolve their conflict go before an arbitrator or judge and jury to solve their conflict. The arbitrator listens to both sides of the dispute, questions you or your representatives, and then renders a judgment. When the parties sign a contract agreeing to arbitration, it is called binding arbitration and is enforceable in court. In non-binding arbitration, the agreement is voluntary, and if the parties don't agree with the settlement, they may move to binding arbitration or try to settle the matter in court. In reviewing the advantages of arbitration, we can see it's a pretty powerful process. Unlike adjudication, both parties enter into arbitration voluntarily, and it keeps one party from using passive-aggressive or sneaky impasse tactics on the other. Everything is brought out into the open. In many cases, the arbitrator has special training in the content area of the dispute. It is readily available for use in situations in which the participants experience a communication breakdown and are no longer able to solve their own problems. And finally, it's a process that can be used for a wide variety of content areas. It's used in professional sports, car insurance claims, and international business. Of course, there are important limitations to arbitration. First, it tends to resolve conflicts solely on a content basis. It tends to overlook relational or emotional issues. So it typically doesn't address relational or face-saving aspects of the dispute. It reinforces assumptions that the parties cannot learn to manage their own difficulties and that only a third party can find a solution. And it also reinforces escalation as a legitimate tactic because intransigence will automatically bring in an outsider. Sometimes people know if they're a stick in the mud, they'll go to arbitration. And finally, we'll end with the most competitive form of third-party intervention, adjudication. It's a process by which parties present their case before a judge or jury because they are unable to solve their own conflicts, and a decision must be imported from the outside. Adjudication can be put into motion without mutual consent. You can sue the other party, forcing a decision whether the other party wants to participate or not. Adjudication assumes that a full argument of each side of a conflict will allow a judge or jury to make a just decision. Of course, Robert Frost once said a jury consists of 12 people chosen to decide who has the better lawyer. Litigating a dispute is both an alternative to negotiation and at the same time a way to force negotiation. Since most lawsuits are settled before trial, it's useful to view litigation as part of a highly structured negotiation game. Filing a lawsuit can bring people to the table to negotiate a settlement. The advantages of going to court include the following: equal protection of the law, which allows everyone access to a resolution process and doesn't require the agreement of the other party. Perceived unfairness can be addressed. Adjudication provides rules for fairness, such as the admission of evidence. The use of professionals to speak for conflict parties is an advantage for those who need real assistance in preparation or presentation of their case. And adjudication serves as a backup for other conflict management procedures. In other words, adjudication provides some motivation to negotiate through other third-party methods because it's an unpleasant eventuality that the parties want to avoid. There are several important limitations to adjudication. It's been overused, and as a result, the court system has been overburdened and misused. Because of the overburdened court system, one state has adopted a rule to help the courts deal with frivolous and unmerited cases. Alaska passed Civil Rule 62, where the losing party must pay the winning party's attorney's fees. However, a recent study has shown that this change or this rule hasn't had a significant impact. In adjudication, conflict parties no longer make their own decisions. And this can be a limitation because important issues may not be addressed in the solution. The adversarial system of the courts operates on a win-lose set of conflict assumptions that encourages escalation tactics. And as I mentioned, adjudication is the most competitive method of third-party intervention.